15. Bobby Martinez and Jose Hernandez are represented by Blair Dunn. And we also have the New Mexico Racing Commission represented by Jerry Walls. Good morning.
Good morning, Your Honor.
Good morning, Your Honor.
We've had some internet issues here, so if you can't hear me at any point, please do let me know. And so the matter before the court is the verified emergency hearing for TRO and preliminary injunction filed by plaintiffs. I also have the response filed by the New Mexico Racing Commission, as well as the reply. Would you like to proceed with that today, Mr. Dunn?
Yes, Your Honor.
Oh, very well. And I see there are others here. I didn't think this would be an evidentiary hearing with witnesses. Do you agree that's the case?
Your Honor, I don't think that there are any facts in dispute that would require testimony today.
All right.
Yeah, Jerry Walls, I agree. I do not know of any witnesses who have been identified for an evidentiary hearing on these matters.
All right. And so, you know, I'm losing my network connection here. Can you hear me?
We can, Your Honor. Your screen is freezing, but we can hear you just fine. So if you don't need for us to see you, it might help. So we don't lose the audio. I think the audio is the more important. Can you see us okay?
I can't see you, but I can hear you. And I'm going to go stealthy here. I think if I'm not on camera, that will help with the audio. So you may proceed, Mr. Dunn.
Thank you, Your Honor. May it please the court. As we've just discussed, I don't think that there are any relevant material facts at issue for the court to issue the preliminary injunction and the TRO and the preliminary injunction. I don't think we need to have a separate hearing. The salient fact, and this is recognized by the hearing officer for the commission in the underlying action, which I just want to highlight for the court. Mr. Martinez, who is the only one seeking injunctive relief today, is no longer a part of that. His dismissal of his appeal has been acknowledged by the commission. So that's no longer pending. So there is no longer any sort of requirement exhaustion that we pointed out in the order from Judge Allison in another similar matter, that civil rights actions under the law in New Mexico do not require exhaustion. But that aside, the salient fact that's at issue here is the amount of time that the commission took between the alleged infractions, and they are still just alleged infractions, and to get this to hearing. Your Honor, it was a full 4 years from the time of the infractions until the commission actually heard these. In the meantime, of course, the New Mexico legislature adopted the Civil Rights Act that deals with violations of the Bill of Rights. For instance, violations of due process. And we make the argument in our reply, and I'll just highlight it briefly for the court. And if the court has questions at any point, please don't hesitate to interrupt me. I'm happy to answer those. They're probably more important than what I have to say. But certainly, if they had gotten around to it within 2 years, I think you can make the argument that Mr. Martinez wouldn't have a Civil Rights Act claim. But it's the additional 2 years beyond the adoption of the New Mexico Civil Rights Act that the commission took to get to this point, which is, of course, recognized in the hearing officer's report, that leads to the due process violation that warrants preliminary injunction at this point. And I will note the response from the commission does not address constitutional violations. It does go through the factors for a TRO and a PI, but it doesn't address the salient and persuasive, if not controlling, case law from the 10th Circuit that deals with violations of civil rights under 1983 in that context in federal court, and on how the United States Supreme Court and the 10th Circuit views those factors that are identical to the New Mexico factors for the issuance of a preliminary injunction. And those are, of course, talked about in our motion. As I said, the case law that we address, for instance, the Heidemann case, I want to say Sebelius, but that's not the right case. The Hobby Lobby case, and some of the others dealing with violations of constitutional rights and the need for a preliminary injunction when a party's constitutional rights are being violated. Those aren't addressed very substantively, if at all, in the response to the motion for TRO. So we've satisfied those factors under the key versus or the key case, and we think that a preliminary injunction should issue today, allowing Mr. Martinez to resume racing during the pendency of this action. And that's probably a good place for me to pause and see if the court had any questions based upon the briefing that we've supplied to the court.
Yes, I do. Would like to know, since Mr. Martinez has, has dismissed his appeal, where does that leave it? Does it leave it because there was a hearing officer's report that was not adopted by the commission? Prior to that, there was the steward's conclusions. What is the status of Mr. Martinez's case right now?
It's not entirely clear. I will say that the most likely scenario is that it reverts back to the steward's ruling as being the last controlling order. But there's an interesting problem with that, because what we have alleged as part of the complaint and verified in this is that, so the hearing officer's report comes out last October, and the commission doesn't act on that until later in the year. And then they still, as of, I believe it was end of February, really don't take any sort of action to even remand the matter back or to try to start setting another hearing to continue on with it. So the due process violation continues to snowball, and we've alleged that their continued delay and their refusal to act on the hearing officer's report is yet another example and another instance of a denial of due process. But for purposes of today and for purposes of this court granting a preliminary injunction, we're not even relying on the due process violations that occurred at the time that the infractions happened. That wouldn't be actionable under the Civil Rights Act, because those are things that happened before July 1st, 2021. We're talking about the delay between July 2021 and July 1, 2021, and when the hearing officer finally issues his report and the commission fails to act on it. The reason we went ahead and filed this case, even though there was still pending in front of the commission, is because we had this act by the commission to try to remand a hearing officer's report back to the hearing officer. And just to give you a little bit of flavor as to why that's problematic and why it's not clear what's going on. So the state of New Mexico put on their case that concluded in July of last year. They rested their case. Mr. Chavez, who's co-counsel with me, is also on this call. We attended that hearing. We addressed the state's case. The state rested. We moved for directed verdict. We've never actually put on anything else. And the hearing officer essentially accepted our motion for directed verdict. So there's nothing as far as facts that we have that we need to offer back into the record, and for the commission to go back and essentially say, well, we want to give the AG's office, who's prosecuting this case for us, a second bite at the case after they have rested. That's a due process violation as well, we think, because, and we included Judge Butkus's order talking about how the commission doesn't have the authority to remand that for the court. There's really nothing left in front of the commission. And so what we're talking about are all of these due process violations by the commission that occur after July 1, 2021. And that's why the court should give Mr. Martinez, at least temporarily, while the court addresses the full merits of the case, order the commission give him his racing license back. He's already served a whole bunch of time without due process. To allow it to continue to go forward would just continue that irreparable harm of the loss of constitutional freedoms that he's already endured quite a bit of. And I will add, we're not asking for anything different in this really than what the commission's own hearing officer has recommended. They just don't want to follow their hearing officer's recommendations in spite of the very blatant and obvious lack of due process that they've not afforded, if you will, Mr. Martinez.
Yeah, let me ask you about that. The case you have here, it's Exhibit 3 to your motion, the Gutierrez case. decided in 2019. What was the procedural posture of that? Because, you know, in the more recent case, there was the issue of exhaustion of remedies, that it not being a final order. And so how is it that, if you know offhand, in 2019, this case, well, this is 2017 case, Gutierrez versus New Mexico Racing Commission, where Judge Butkus decided that the commission was not appropriate for the commission to remand the case to the hearing officer after the first hearing. But if there was not a final, order because it was on remand, how is it that this came before Judge Butkus and was decided? Do you know?
Your Honor, if the court would permit, that was actually Mr. Chavez's case. Would you permit me to hand off to him for a minute so he can give you the clearest picture of that?
If you don't object, Mr. Walls, I'd be interested to know.
No, Your Honor, that would be fine then.
Yes, thank you.
I hadn't prepared Mr. Chavez to be on camera. If he's able to be on camera, we'd appreciate it. But if he can't, I'll do my best.
Good morning.
Good
Does
morning.
everyone hear me?
Yes.
Okay, wonderful. My camera has been very glitchy, so I decided to just go stealth, and if everyone can hear me, I'll just proceed if it pleases the court.
Yes.
Thank you, Your Honor. Your Honor, that particular case, we went through the hearing officer procedure, and the hearing officer rendered a report dismissing the case in its entirety. And it was then, the clock was ticking for the Racing Commission to either adopt or review the report of the hearing officer. During that time, they decided to remand it. And so they remanded it. I appeared with Mr. Gutierrez at the hearing. We indicated that we objected to anything going forward because there is nothing in the administrative code that allows them to remand the decision of hearing officer. In fact, the code is very clear. It's to be adopted or adopted or ratified by the Racing Commission. But in very, very strict circumstances can it be sent back, for example, like new evidence or something to that effect. That didn't happen. And so we appeared, we objected, we didn't put on any evidence, we didn't put on any testimony. In fact, we noted our objection, we left. The Racing Commission held their hearing without us remaining for the rest. And then when they submitted the hearing officer's report from a different hearing officer, it was then adopted by the Racing Commission, and then it started the time for our Rule 75 objection at that appeal. At that point, we then filed it with Judge Butkus, and the basis of our Rule 75 is at the time that the first hearing officer dismissed this case in its entirety, and there being no exceptions to any of the extraordinary type of circumstances for the Racing Commission not to adopt it, they simply made up a rule that they can't make up, and that is to remand something that they didn't like. So Judge Butkus agreed with our position, reviewed the New Mexico Administrative Code, and saw that there was no basis for them to do that. So that's why he dismissed the case in its entirety, and that's where we're at today. Mr. Dunn and I have both sent copies of that to the Racing Commission and their counsel, of which they tend to think that doesn't really apply because they're hoping that another judge sees it differently. The problem that I had, Your Honor, with the finality of the holding is once the hearing officer makes a recommendation, the clock starts ticking within a certain amount of, I apologize. Once the case in chief is finished, the hearing officer has a certain amount of time, 30 days, to provide their report. And if that report isn't done, then dire circumstances could require a dismissal. If it's turned in, the problem that we have, both Mr. Dunn and I, is the Racing Commission then doesn't have any requirements as to when they can send this to the Racing Commission to adopt or make any decisions on the hearing officer's report. And that's kind of essentially what Mr. Dunn has stated earlier today is I mean, here it's been quite a long time, years since this started, but we received that dismissal, the recommendation of dismissal from the hearing officer back in September, October. Do you recall what it was, Mr. Dunn? October. So because it's silent, the Racing Commission Administrative Code is silent as to when a deadline for the Racing Commission to make a decision. They're taking their sweet time, and we're without remedy. Now, Mr. Dunn he represents Mr. Martinez. I represent Mr. Hernandez. Mr. Hernandez has not withdrawn his appeal and is going forward. And so we're in the same position that we were in previously, where we're still waiting. And this game that the Racing Commission is playing with the finality of a decision, I mean, the finality, I think, is already there. I think
Okay.
that the hearing officer already rendered their decision. The Racing Commission doesn't like it. And instead of even attempting to follow what's set out in the administrative code, they just want to remand it for unknown reasons. And then they keep tabling it at the Racing Commission hearings. And so when
Okay.
it's tabled-
I think that does answer my question.
Okay.
Thank you.
Thank you,
Stand by one moment, because I thought I saw something in the Gutierrez. Just 1 minute. Not sure if I read it there. I thought it was there that I read it, and it said that well, I think it quoted the statute or maybe the regulations as to the circumstances under which the commission may remand to the hearing officer. But I think you've answered my question about the Gutierrez case. I appreciate that, especially since I didn't realize it was your case. That was really helpful. Thank you.
Your Honor,
Getting back to Mr. Dunn.
yes, Your Honor. And I know where you were looking. I was actually looking at the same part of Judge Butkus's decision. It's at the bottom of page 6. And it cites to the second AMJUR on admin law, section 352, the power to remand a case. And just so I'll pull it up, I'll read it for the court right quick. Although an agency has the power to remand a case to a hearing officer to obtain additional evidence on specified issues, an agency should not remand a matter for inclusion in the record of evidence unless the evidence could not have been introduced at the initial hearing in the exercise of reasonable diligence, or the evidence was improperly excluded at the initial hearing. That's what Mr. Chavez and I are talking about, that those are the circumstances where the Racing Commission could, but this is a circumstance where the commission had all of this information. They rested their case. None of their evidence was excluded by the hearing officer, as he notes in his report. And even still, with all of that, the commission is now trying to remand it back to the hearing officer because they don't like the recommendation, not because there's some problem with the evidence. And so that's what we're saying is yet another violation of due process for Mr. Martinez. And I'd like to just quickly highlight, I know you didn't ask about this and I won't belabor it, but there is a difference between Mr. Hernandez and Mr. Martinez. Mr. Martinez's livelihood is completely tied up in this, and he's been deprived of his chosen profession, his livelihood, that property interest he has in that for 4 years now, without any sort of due process to do that. And that's why we're asking, and that's why this is an extraordinary relief situation, and it is warranted, because at this point, you know, they have in effect taken him hostage and held him in an administrative process for a very long time without affording him that necessary due process, and deprived him of his property interest in his chosen profession. So with that, I'll hand it back to you, Your Honor, if you have any further questions.
Oh, with respect to the remand, the recent remand, I guess that would be your exhibit 4, order on remand. It's to the extent that the commission is requesting reconsideration by the hearing officer. Would that be limited as it generally is in reconsideration issues? Reconsideration situations to it's usually limited to one of 3 reasons for a remand. Facts that are available now that were not available previously at the time of the original hearing, a change in the law, or manifest injustice. Is it your position that any remand by the commission would be subject to those conditions.
Yes, Your Honor. And I think that you've touched on the important point. And Mr. Chavez alluded to this. I want to be clear. The commission, when they receive one of these, can either reject, modify, or adopt the recommendations. Those are the three things that they can do. They don't ask him to change. It's the reason it's improper is because those three factors that Your Honor just talked about are those three things that they can remand it back to do. That's none of the three that are actually available here to them. The only manifest injustice that could befall anybody here is Mr. Martinez for the delay. They can't ask for new facts because there are new facts that weren't available to them under the Amjur citation we just discussed. And now I'm drawing a blank on the third one, Your Honor, but that one's not met either. They don't, none of those three, there hasn't been a change in the law. I'm sorry, that's the second one. None of those are present here.
All right, but if the commission can modify the hearing officer's decision as it sees fit, isn't it a moot point as to whether or not they meet one of the three criteria for reconsideration?
I think that's right, Your Honor. So if they don't want to accept his report and they wanted to reject it, they could have done that and acted on the report and sent this off to our Rule 75 appeal. We probably wouldn't be here today in front of you if that were the case. They refused to do that. Instead, they did the one thing they can't do, which is remand it because none of those three factors are met. And so that's why we're here today in front of you.
All right, and so just to make sure I understand, so Mr. Martinez, if they did modify it and have a final order, I'm talking about the commission, then Mr. Martinez could have appealed under Rule 75Q. Is that correct?
That's right. And certainly after 4 years, we should have been to a Rule 75 before today.
I see. And is it also true that there is no time constraints in either the New Mexico Racing Commission's Act or the regulations there under that specifies the time after which the hearing officer's report is issued and the commission must act? Is there no timeline there?
There's no timeline. And honestly, Your Honor, there's no timeline as to when they're supposed to bring these. It's probably a rule or regulation that needs to be adopted for the commission and the NMAX to kind of avoid this discretionary problem where they wait 4 years to do something. But the only timeline that exists is the one between when the hearing officer, when the case closes and the hearing officer issues his report to the commission. That's the only deadline in the time to hear. So what we're asking and saying is that it's a due process violation because it doesn't meet a reasonable opportunity to present his case. That's why it's a due process violation, because 4 years or 2 more years beyond the adoption of the Civil Rights Act is not a reasonable opportunity to present his case. And we point out that when we did go through this process in July, and we went through that, the infirmity of all of the memories of the state's agents that were responsible for retaining this information was very suspect. That's the reason we included those facts regarding what had gone on at the time of the infractions, and the fact that none of the state's witnesses could really remember what had happened at that point 4 years ago, just like the rest of us.
Regarding these summarily suspension, when Mr. Martinez was originally suspended, has he been suspended since July 2019, or was it in March 2020?
No, he's been suspended since July of 2019, Your Honor.
And is there any timeline between a summary suspension and the date on which the stewards must meet?
No, unfortunately, there's not. That's why we felt like that was the start of this denial of due process. Mr. Martinez has the opportunity to ask the racing director for a stay or for them to agree, and he had the opportunity to go ask the district court at that point for a TRO. I took over closer to his appeal after I wasn't actually counsel for the Stewards Commission hearing for him. It was another attorney. And then I took over after that for the appeal. So we could have gone and asked for a TRO along the way from the district court under the provisions of the Racing Act, but he didn't do that. And we felt it made more sense to get to a hearing and to address these due process violations that we believe occurred in the infractions. But since then, in essence, those are mooted out by the extensive delay that happened after the stewards hearing.
Okay. And can you address the issue of if regulations are adopted and properly adopted, and there's been no objection to them, if those are complied with, are remedies still available under the Civil Rights Act?
Your Honor, I think that gets to the exhaustion question. I mean, Judge Allison went over that when it comes to a violation of civil rights, that this court, the district courts in New Mexico, have exclusive original jurisdiction over those, and the commission doesn't have any jurisdiction over Civil Rights Act violations. We're allowed to come here without exhausting those administrative code remedies that they've adopted. If a constitutional violation occurs, we get to come here in the first instance and ask you for an injunction, because that's what the Civil Rights Act provides for.
I'm not exactly sure how to ask this, but wouldn't it be a defense to say that the agency, or in this case, the Racing Commission, acted in accordance with its regulations?
It would be a defense, but I don't think it would be a good one, Your Honor, because ultimately, even if they did adhere to their regulations, they did so in a manner that violates due process. So it doesn't really matter whether or not they follow the regulations if they applied them in an unconstitutional fashion.
Okay. Anything further, Mr. Dunn?
No, Your Honor. Thank you.
Mr. Walsh, did you wish to respond?
Yes, thank you, Your Honor. And also with me is Alicia Walsh. She's an attorney also working on the case. So I don't know, she might input a little bit, I don't know. But first of all, let me say that the procedural posture of this case changed somewhat, even dramatically, just last Friday when Mr. Dunn filed on behalf of Mr. Martinez the withdrawal of any further participation in the adjudicatory proceedings before the commission. That changed quite a bit of the analysis, I believe, as it relates to Mr. Martinez. Also, we're glad to note that finally, through the pleadings, we know that it's only Mr. Martinez who is seeking the injunctive relief, the temporary restraining order and injunctive relief. The pleading itself was a bit confusing because they used the word plaintiffs and then plaintiff Martinez, but now we know it's just Martinez who is seeking the relief. The court's very first question asked of Mr. Dunn is dispositive of why the TRO and injunctive relief should not be granted. We need to look at the state of the record as it now exists and determine is that controlling as to where we're at right now. So what we have now are the rulings from the stewards that found Mr. Martinez committing multiple infractions that were very serious, including providing an improper drug, ostarine, to a number of horses. And those rulings are now standing. After those rulings are made pursuant to the statutory scheme, then the appeal process can follow up through the commission and have the hearing, and it's all laid out in the New Mexico annotated code. Both Martinez and the horse owner did follow the appellate process. They're going through the appellate process, and then, as we know, there were various things that happened as set forth in the Attorney General's exceptions that caused delay in the proceedings, including intentional delay, we believe, by counsel, be it for some tactical reason, we don't know, but almost a year of delay at the very beginning, whenever these things should have been addressed, was caused. And we believe we can show this in court once we go down the road in the civil rights case, New Mexico civil rights case, if that's where the court and everybody ends up going with this, but was not caused by the commission or the commission's agents or anybody else. Then we had the COVID and entries from the court about how things are to be conducted. State personnel was off, etc. In the exhibit that we attached, the exceptions filed by the New Mexico Attorney General's office to the hearing officer's report, he lays this out very carefully, and those explanations and factual history are right on point. We don't think there's been a due process violation anyway. A predicate of the relief that Mr. Dunn is asking for assumes or presumes that a due process violation has occurred. And we believe that it has not. We believe that there would have to be a lot of testimony, factual testimony, evidence to support that predicate that the court would need, we believe, to enter any kind of injunctive relief at this point in favor of Mr. Martinez. And that hasn't occurred. Now, Mr. Dunn talks about the recommendations of the hearing officer. And I believe he acknowledged that those are not binding, they're not controlling, they're not in order. That's just part of the procedure. As noted, the hearing commission, can either accept them, modify them, or reject them, and send it back to the pursuant to the remand order, which we did. But what Mr. Dunn did not say or talk about were the findings by the hearing officer of the infractions that were committed by the plaintiffs in this case, which he also found aggravating factors and conditions which clearly preclude the granting of equitable relief and temporary restraining order to the trainer Bobby Martinez, because those particular findings, though not in order, do set forth with a great deal of particularity what has occurred here. And the Attorney General's office, as the court knows from our briefing, calls this one of the most egregious cases in the history of New Mexico racing. Now, it seemed to me, at least hearing Mr. Dunn, he was somewhat attacking perhaps the interpretation of the statutory scheme for constitutional irregularities, or perhaps there not being sufficient direction in the New Mexico codes as to when certain things are to occur and what deadlines. That is not before this court. And regardless of that, we believe that there are that the statutory scheme is complete, it's constitutional, and is constitutionally applied. So it's facially constitutional and constitutionally applied on its face. But again, now we're getting outside the realm of what they're asking for here today. What I would believe would be appropriate, Your Honor, excuse me, is to, at this juncture, deny the motion for temporary restraining order and permanent injunction. Hold in abeyance your decision, perhaps maybe until further briefing relating to whether this court wants to exercise jurisdiction over the New Mexico civil rights claims. As noted, and I believe Mr. Blair is probably correct there, under the New Mexico Civil Rights Act, this court would have original jurisdiction, and there's no exhaustion of remedies required in the act itself, as we candidly pointed out in our response brief. We did look at this exhaustion issue, ripeness issue, and see that it's somewhat in a state of flux, obviously, here in the New Mexico courts. We don't know how that's going to come down. Those are legitimate concerns raised by the New Mexico Racing Commission as to whether this court should proceed, even though it may have or it does have jurisdiction based on these other doctrines until such time as that is clarified. Whenever we look specifically at the factors, which we did address in our reply, and we apologize for any confusion, the initial part of our reply brief dealt specifically with the injunctive relief and TRO, which came before any argument relating to any type of dismissal or exhaustion arguments on behalf of the commission. But when we look at the factors, Your Honor, that I think we all agree we cited the same factors. Here it says plaintiffs, but Bobby Martinez cannot show irreparable harm. These sanctions were imposed by the stewards pursuant to due process that he received at that time that was provided under the statutory scheme. He was sanctioned, fines were imposed, and that occurred in 2019. I'm sorry, 2020. What has changed since there? He's wound his way up through the administrative process, and he's now decided to abandon that process. But the imposition of this sanctions was created from his own conduct, and I have not seen any briefing per se that says that the ostarine was not found in these horses, or that Mr. Martinez was not the trainer. And this is very, very, very serious in considering the equitable relief that's requested. The status quo would be to keep it the same, to protect the safety, welfare, and integrity of the horse racing industry. That is extremely serious whenever that type of drug that's not allowed is utilized in the horse racing industry. It for people that watch horse racing, bet on horse racing, attend horse racing, the jockeys, everybody's affected by this negatively, and could lead even to death of the horses. So we need to keep the status quo as it is now, as it promotes and keeps the safety, welfare of all people that engage in this industry, and also protects the integrity of the horse racing industry. Another factor is the public interest versus the interest of Mr. Martinez. The public interest is to see a horse racing industry that is regulated properly, where the horses are safe, the participants are safe, the people that attend are safe, and that should not be changed. The public interest highly favors the continuation of the status quo as it is now, and the likelihood of success. All right. And by the way, any of these one factors would prevent the issuance of the TRO or preliminary injunction. We don't need to meet all of them, but I think we do. But the likelihood of success, and again, without getting into argument of the case specifically, we think is very low and will not happen. We think that the statutory scheme provides due process. We think that given everything that was happening based on the pandemic and other matters, as well as conduct of the plaintiffs and their counsel, slowed down the process to a certain degree. And we'll be able to prove that, we are fairly sure, once this comes to trial at an appropriate time. So we don't believe there's any kind of due process violations. Now, the New Mexico Civil Rights Act, fairly new, as we all know. We all know what due process standards are under Section 1983 for federal claims. We don't know what the New Mexico judiciary is going to carve out as the standard or burden that must be met to prove a due process claim under the New Mexico Constitution pursuant to the New Mexico Civil Rights Act. But regardless of what it is or what it might come down to be, having engaged in many, many years of civil rights litigation, I don't believe that the standard will be one that plaintiffs can meet just based on a review of the record. So, Your Honor, if you wanted to or believe that there should be some type of injunctive relief that needed to be entered, you literally have to go at this point to see if has been, in your belief, some type of due process violation, even though no evidence has been presented in your court, no testimony has been taken, no witnesses have come forward to testify. No, only limited parts of what occurred at the administrative process have been attached as exhibits to Mr. Dunn's pleadings as well as to ours. To go and try to review all the transcripts, the testimony, the test results, and everything else, it would be almost an impossible task. And that's why we have to rely on these adjudicatory hearings that are specially carved out, special statutes to address these very same issues. And what Mr. Dunn is trying to do is get you to forget all that. Forget that lengthy record that has been made in the adjudicatory process. Let's pretend like it doesn't exist. Let's just say, look at how long that this has taken. Have you believe that there has been some, as a predicate, some due process violation to give you a hook of some sort, a legal hook, then to issue the TRO and injunctive relief. And that is not appropriate. That is not what the law would call for. So for those reasons alone, Your Honor, we would ask that the TRO and the injunctive relief be denied if the conditions should change and we are proceeding before this honorable court. They could always try again. Maybe they would have some different evidence or some type of documented evidence that would perhaps be more persuasive. Lastly, and then subject to the court's questions, there is an adequate remedy at law. Should they prevail under New Mexico civil rights claim, damages could be awarded, and we believe that the damages would be sufficient if they could prove to the satisfaction of the court or a jury that there have been constitutional violations of the New Mexico Constitution which warrant relief. So with all those factors, Your Honor, we would ask, as we stand here today, that the injunctive relief request be denied.
Thank you, Mr. Walls. I want to give Mr. Dunn an opportunity to reply. But before that, when we look at the factors that you just reviewed, under the likelihood of success, are we looking at the likelihood of success in the underlying case or in this separate case, this Civil Rights Act case?
Well, that's a very good question. I think we're looking at the likelihood of success in the, this is just off the top of my head, obviously. I think we're looking at the likelihood of success in the civil rights case. However, I want to qualify that just a touch in that whatever finally is determined from the adjudicatory process may have precedential value as to certain issues that exist in the civil rights litigation. And we know that from all the federal litigation we do, how these adjudicatory bodies rule, and if their rulings are not disturbed or set aside because they were unconstitutional, they have precedential value as to the finding of what may occur at in a different jurisdiction. We think as to Mr. Martinez, he has now abandoned going forward in the adjudicatory process.
Where do you want to stay?
The rulings from the stewards are the law of the case. We believe they will be the law of the case. Might take some briefing and we'll argue about it, I'm sure. But once the smoke clears, those rulings were adjudicated. Well, those rulings are in place. There was due process given at the time by the stewards, and now they're not being challenged, and they could have been, but that was a decision that Mr. Dunn apparently made to abandon that process. And there were on the remand order, there was an attempt to get a hearing scheduled in April, and that still was in process. So whenever they're trying to say that there isn't due process ongoing, that's not true. Now, whether it might be what they consider too slow, that's a different story. But there is due process. It's afforded by the statutory scheme. And they're not challenging, at least so far, the constitutionality of the statutory scheme. And that was a question the court somewhat asked about the statute and statutes that everybody's proceeding under.
Thank you. And Mr. Walls, you made mention of, and I also read, there was mention of that this was an egregious case in the history of horse racing.
Right.
Isn't that a completely separate issue than the issue of whether or not the plaintiffs in this case were afforded due process?
Well, number one, we believe they were afforded due process, but the fact that it's an egregious case, I think that goes more to their request for the Martinez's request for the TRO and injunctive relief, because that goes to the public interest prong of the analysis. That's why I put that in there. Certainly, there's cases, criminal cases, Section 1983 cases, other cases where there's been an egregious conduct, but if there is some type of constitutional violation, right? If there's a constitutional violation, that might preclude the agency or the state or from proceeding, but they have to prove that. And here we don't believe that there has been any kind of due process violations at all.
All right. And thank you. Anything further, Mr. Walls?
No, Your Honor. I think it's pretty well covered. I think the record that the court has in front of it at this point, that the court should not grant the injunctive relief or TRO. And again, if the situation changes when they're developing their theories about due process in this litigation, they might want to make another run at it. I don't think that they'd be precluded, but I don't believe it exists. Well, I don't believe based on the facts and the law, it does not exist now, in my opinion. Thank you.
All right. Thank you. And Mr. Dunn, before you make a reply, I had a question about the other case that you cited. It was a more recent case. It's called Batten. It was a Judge Allison case, a recent one, I'm going to say from 2023. And I believe.
Yes, Your Honor. I believe you're talking about the Brad Bolin case. That's a First Amendment case. Do you have anything specific on the case that you'd like for me to explain? Your Honor, I can't hear you. I'm sorry, you're on mute.
Sorry about that. Yes, it's called the Batten case, I believe, the Brad Batten case.
Bolin. Yes, Your Honor.
Okay, so on that case, I'm going to have to take a closer look at it right now. But if you could refresh my recollection, why was it sent? Why was it certified for an interlocutory appeal? Because at some point, I believe, you know what, stand by 1 minute. I need to actually have that case here.
Your Honor, I can give you the full synopsis elevator pitch on that one very quickly and explain the interlocutory appeal and the procedural of that. So that's a case where Mr. Bolin, as a client of mine, he engaged in a discussion, a heated discussion with some of the stewards at one of the tracks over the phone, and they charged him under the Racing Act with impertinent conduct. We proceeded through the administrative hearing in that case in a similar fashion. It looked to be somewhat of a, I don't say this lightly, but it's kind of a joke in the hearing in that one as well. we ended up with a transcript where the hearing officers or the stewards are actually still on record in the recording and using interesting and colorful language and discussing what a stupid case it was. It ended up becoming a problem. And so we went to Judge Allison and we asked him for a TRO in that case, and then PI in that case. He denied those. The basis of his denial was that he didn't believe that the speech was chilled. So it was the chilling of a First Amendment speech by the administrative process. So we didn't meet the likelihood of success, I'm sorry, not the likelihood of success, the irreparable harm element in his decision on our TRO in that case. In the meantime, the case went on, and the decision we've included is the result of cross motions for summary judgment between the parties, where there was an allegation of or a defense of immunities by the Racing Commission, prosecutorial and judicial, essentially quasi-judicial, and then also a Butts versus New Econ administrative privilege, essentially. Judge Allison didn't agree with any of those immunities, and so he certified it for an interlocutory appeal. And go ahead, Your Honor.
All right, and that is the heart of my question, where he says on page 4, plaintiff's vindictive prosecution claim is allowed under our Civil Rights Act. But then, is that the question he certified for interlocutory appeal?
It was essentially, well, I'm trying to remember, because there was a writ of error and a petition for interlock, and essentially the Court of Appeals granted both and combined them. So they're both part of the appeal. One dealt with immunities, the other dealt with whether or not there is even a vindictive prosecution underneath the Civil Rights Act under New Mexico. And it is that's an issue of first impression. That's the writ of error, I believe. And then the immunities, no, I'm sorry. The immunities is the writ of error. The interlock is the vindictive prosecution, if I'm procedurally correct.
So would it be fair to say that that's not an issue in this case, Mr. Martinez's case, because due process would absolutely be allowed under the Civil Rights Act? Is that your position?
It is, Your Honor, and it's not novel. And that gets to the first thing I was going to say in response to Mr. Walls, but I don't want to jump ahead if you've got additional questions.
That's all of my questions on that. Thank you.
Okay, so Your Honor, as we pointed out in our complaint, and this goes to the likelihood of success, what we're asking the court to look at here is whether or not Mr. Martinez's due process claim for his denial of due process in the appeal, and that's the reason I draw the bright line between the appeal and the steward's hearing, is that what happened after he filed his notice of appeal is what gives rise after July 1st of 2021 to the Civil Rights Act claim. Now, I can certify to the court, I don't know about necessarily what went on as far as Mr. Martinez and his counsel prior to the steward's ruling. So between July of 2019 and March of 2020, I'm not aware of any intentional delay. I think that that's an irrelevant fact that I don't think is supportable, but it doesn't matter for today's analysis. What we're discussing is whether after July 1st of 2021 to July 1st of 2023, that period of time is accepted under the law as not being a due process violation. Specifically, and we do know what a due process violation looks like in New Mexico. That law is well settled. We cited in the complaint to State XREL Children, Youth and Families Department versus Maria C. That's 2004 NMCA 083, and specifically paragraph 26. The Supreme Court says the due process is an opportunity to be heard at a meaningful time in a meaningful manner. It is not a meaningful time 4 years after the infraction occurred. That's why this is a due process violation, and why we are likely to succeed on the merits of the Civil Rights Act claim is because he has been denied in the appeal process an opportunity to be heard at a meaningful time and in a meaningful manner. That we think that we meet that for likelihood of success on the merits. I think that's not even a close call when you get into talking about 4 years from the infraction to, oh, let's give Mr. Martinez credit or penalize him for a year's worth of that time. It's still 3 years worth of time that the commission essentially had and did nothing on it. If even if we divided up 25% and 75%, it's still such an egregious violation of due process because it's such an egregious amount of time that we're likely to succeed on the merits of the case. So the next thing that Mr. Walls argues about, and I think misses the point, and this is what I raised at the beginning, is that when we discussed the factors in our motion, we pointed out the case law from the 10th Circuit that deals with, for instance, balancing the balancing of the hardship between Mr. Martinez and the commission. And we pointed out the Awad case, which is Zeriax, which is a 2012 10th Circuit case. When a law is likely unconstitutional, the interests of those the government represents, such as voters, do not outweigh a plaintiff's interest in having its constitutional rights protected. You apply that to this situation, the interest of the Racing Commission in promoting racing and regulating racing so it's safe does not outweigh Mr. Martinez's constitutional interest under 10th Circuit for purposes of a TRO and a PI. For purposes of today, it does not outweigh his interest in getting his license back. Then we turn to the public interest in these egregious alleged violations, putting aside the due process violations that occurred and how they came about collecting those violations. And the 10th Circuit is again, and this is the Hobby Lobby case that I mentioned, has been very clear that when it comes to the public interest, that it is always in the public interest to prevent the violation of a party's constitutional rights. That's Hobby Lobby Stores Inc. versus Sebelius, 723 F3rd 1114. Again, that's a 2013 case from the 10th Circuit. Again, addressing constitutional violations like we're addressing here today. So this isn't, we're not stretching for the Civil Rights Act today. This is well-settled Civil Rights Act law from the 10th Circuit. And then finally, the irreparable harm. We discussed that the loss of a property interest and the loss of constitutional freedoms is always irreparable harm. The fact that there may be a remedy for these due process violations that undo some of the damage, if that were the standard, there'd never be an injunction issued in a Civil Rights Act case under Section 1983, because if it can be remedied with money, sort of loss of life, there's very few things that fall into that. But that's why the 10th Circuit is helpful in this, because they hold the loss of constitutional freedoms to be irreparable harm. That's the Heidemann case that I talked about. So we meet all four of the factors. And I will say I don't think it's even close for the likelihood of success on the merits, the public interest, the balancing of harms, and the irreparable harm to Mr. Martinez. All of those counsel the court today when relying upon 10th Circuit's persuasive, if not, very persuasive authority to issue him an injunction to allow him to have his license back, at least during the time where we look at this. I think ultimately he's gonna get his license back, and this is going to go on. But that's how I view the likelihood of success on the merits. Mr. Walls and the commission see it differently, but that's where we are, Your Honor.
Okay. All right. Thank you. I will make some findings now. Excuse me. Oh, one last question for you, Mr. Dunn. You requested on behalf of your client a TRO and a preliminary injunction. It would be more appropriate now for one or the other, and if so, why?
Well, Your Honor, a TRO would be issued if there would be a need to come back within the 10 days under the rule for an evidentiary hearing. If the court thinks that would be helpful, we're happy to do it that way, and you can issue a TRO, and we can come back and we can have this discussion about whether or not there's some justification for the delay. I thought we started the hearing with an acknowledgement that there weren't really any material facts in dispute for today's purpose, but you know, I don't want to cut anybody off from the opportunity to put things in the record if especially if the court thinks it would be helpful. But I think that the court, in my opinion, could go ahead and issue the preliminary injunction today. I don't think that there's any evidence that changes the fact that 4 years is, or even 2 years is too long. And I think for likelihood of success, that's the only factor that we would really need to see evidence, if there is any evidence that could possibly change that.
Mr. Walls?
Well, Your Honor, I don't know what the court is going to do here, grant the TRO or not, but if the court's saying about entering a preliminary injunction, we would want a hearing on that because this is a very important matter. And if that is the case, we'd probably want to put witnesses in and other items, exhibits and the like. So that would be my preference if that's the direction the court wants to go.
All right. And if
Your Honor,
yes,
might I add one thing?
yes,
If the court's inclined to go that route and to have an evidentiary hearing, I would ask the court just to hold off. I think issuing a TRO to Mr. Martinez for a 10-day period or whatever, given where the state of racing is, and getting him spun up in his business might be problematic for both the Racing Commission and for Mr. Martinez. It might make sense that if that's what the court is inclined to do, that we have have the evidentiary hearing and you just make a decision at that point. I'm trying to get Mr. Martinez back to racing as quickly as we can, but I don't want that to be a herky-jerky stop and go, because that might actually cause him more problems if he starts spinning up to work and then isn't actually allowed to do so at the end of the period of time when the TRO ends. Does that make sense? Sorry.
I generally do think of the TRO as, almost in the same sense as an ex parte order where the parties have not had a proper opportunity to prepare, and that it should only be in effect for a short period until they have an opportunity to respond. I am going to enter this as a preliminary injunction, but it's very limited. This is going to be based on the preliminary injunction is based on the most recent, not to speak of any others, but just the most recent remand. The exhibit 4 of the motion on December 13, 2023, after the hearing officer prepared the report and recommendation for the dismissal, the Racing Commission remanded it without any reason that is generally cited in a motion for reconsideration. Specifically, there was no citation, no reference or request to have this remanded. It was not a remand based on either a change in the law or so that the Racing Commission could present some additional facts that were unavailable at the time, or for manifest injustice. It was remanded without any reason for the hearing officer to reconsider it. And that was a violation of Mr. Martinez's due process rights that would be considered as part of this civil rights action. And so based on that alone, I will enter the preliminary injunction at this time. Mr. Dunn, can you, yes, and of course, based on, I did too look at the factors, the Key versus Chrysler Motor factors. And I know in connection with the public interest, I wanted to point out specifically Mr. Walls, the public interest going forward will not be infringed upon because, of course, there can be ongoing testing in compliance with the act. So I don't see any potential for future harm to the public in connection with the irreparable harm. There is that potential when someone is excluded from their livelihood. And so balancing the hardship, I do find that the key factors have been met. I agree with you, Mr. Walsh, that the likelihood of success here is now we're in the only case I have here. Of course, it will be influenced by what's happened in the past, but I'm looking at the likelihood of success in the Civil Rights Act case here. And so based on, excuse me, the remand that was in violation of due process, I will find that there is a likelihood of success. And so that will be the order of the court. And Mr. Dunn, if you could present a proposed order, I'll go ahead and have that entered.
Yes, Your Honor. I'll get with Mr. Walls and we'll get you an agreed upon form of order.
Thank you. And anything further, Mr. Walls?
No, Your Honor. Thank you.
Anything further, Mr. Dunn?
No, Your Honor. Thank you very much for your time today.
Thank you, counsel, both of you. I appreciate it. And Mr. Chavez, at this time, we'll be in recess. Have a good afternoon.
You too, Your Honor.
Thank you, Your Honor.